In this video, we will explore different paths you can take to find relevant case law. There is no single method to arrive at a legal authority, and you need to be familiar with different approaches and be prepared to apply different tactics in the same research project. When deciding which approach to start with, you should evaluate how much information you already have, and as you find useful authorities, you can change your research path by using those authorities to find further relevant cases. We'll look at 5 broad types of case research approaches: retrieval by citation, using secondary sources, searching, going from case to case, and going from statute to case. We'll look at how you might apply these different approaches to find this case we looked at in the previous video, Coos v. Roth. If you already have the citation to a case, your job is going to be very straightforward. You can simply type the citation into your database of choice and go straight to the case. On the other end of the information spectrum, if you not only don't have a citation to a case, but you also don't know about other related laws, or even which terms to use in a search, you would do well to start your research with a secondary source. In an earlier video, we discussed different types of secondary sources and which ones might be more appropriate in different contexts. Secondary sources will concisely state how the law works in a given area and organize the rule statements in a logical fashion, so related rules are grouped together and given relevant headings. You can use the indexes or table of contents of a relevant secondary source to track down a rule that should be related to your problem. Whenever a reliable secondary source provides a rule statement about the law, it will contain a citation to the primary authority that stands for that proposition. Now, let's examine techniques we have not covered in past videos. First, we'll look at how you can locate relevant cases using a database's search function. This technique is most effective when you already have a sense of what language you would expect to find in a relevant case, which would mean that you know a bit about the law, and you know the terms of art that the court would include in its opinion. Searching is a more involved process than simply entering some search terms and finding the best cases. It's an active process that requires carefully sorting through results. One way to think about database searching is to break it into 3 steps: searching, filtering, and then browsing results. The heart of the search process is coming up with a good search string, that is, the set of words and connectors that the database will use to find results. There are 2 broad approaches you can take to coming up with a search string: natural language or terms and connectors. Natural language searching is when you simply include a set of words that seem related to your issue and would expect to find in your document. Modern database algorithms are fairly efficient at interpreting how to prioritize those terms and look for similar words to find relevant results. But it does mean that you are relying on the algorithm to do some of the work for you, which may not always be successful. The alternative would be to structure your word choices in terms of their logical relationship to one another and how you'd expect them to appear in the text of the opinion. This can create searches that look a little bit funny at first. Now, if you have a strong sense of the exact vocabulary you would expect to be used and how the different terms would be used together, this can be a good way to narrow your results. You might also hear this called Boolean searching. The next video will go into detail about how to craft a good search string using terms and connectors. One other thing to note: if you start entering terms for natural language searching, Lexis and West may suggest a research question for you. If you see a prompt that matches your question, you could use that as your search string. After entering your search string, you need to refine your results and make them more manageable. The ideal result list will be small enough that you can quickly review each case. Now, if you came up with an exceptionally tailored search string, you might receive a small list of relevant cases, but more often than not, you will instead have a rather large list of results that you will want to winnow down. You can narrow the amount of results by applying various filters which will exclude the results that don't fit that criterion. The first step is always to set the database's jurisdiction filter to the right of the search bar. You can find these filters in a panel to the left of the results list. This is a type of interface you'll see in many advanced search services and not just Lexis and Westlaw. The first filter you'll likely want to apply is the content type filter. This will let you select among different types of legal authorities. The next category you will want to check is the practice area, topic, or key number filters, as these will help you choose between different issues of law. Another way to really limit your results to a manageable level and focus on cases that are much more likely to be controlling is to go into the jurisdiction or court filter and select the relevant high court. If there is a case from the high court that stated a rule on the issue, it will be more precedential than a case from an intermediate court. There will also be fewer cases to look through. Now, that smaller amount will be more manageable, but if the high court never ruled on the issue, you will be excluding relevant cases. Once you've narrowed your results list, you need to evaluate those cases to determine whether they meet your needs. I like to think of this as a layered process, where you start by looking at as many results as is feasible, but only giving them a cursory look to find signs of obvious relevance. But as you continue the process, you start looking into them in more depth. My personal approach is to expand the level of detail visible for each result. Then, look at obvious indicators in the synopses of the cases, such as the category of case identified, summaries of the holdings, or snippets of the case's text that are included. If the case seems clearly relevant, I open a tab in my browser for it, and after selecting several of the top results, I start looking inside those cases. Now, I want to look for indicators of relevance, such as looking at the headnotes to try to find a rule statement that seems related. Also, in this step, I use the database's ability to jump down to where my search terms appear in the text of the case. That will most likely be the most relevant passage of the opinion, and if the discussion seems to be irrelevant, it's a good sign that the case is not for me. Whenever I see a holding or rule statement during this cursory reading that seems related, I make sure to highlight it. Then, if I feel like this case will be useful, I save it to a folder for this sub-issue, and I add a note to the case that says why I thought it looked relevant. I might repeat this process a couple of times, depending on how many results I have. And if the cases in the search are generally not very useful, I might try revising my search term, or take another approach altogether. If you're using Lexis, another feature to quickly evaluate the weight of cases is to look at the Ravel view of the results lists. This view arranges the results by year and hierarchy of court, and then shows a connection for every time one case cites another in your results, and it displays the more heavily cited cases with larger circles. Those more heavily cited cases might be the ones to look at first. Any case you have on hand that you have identified as being relevant can be a great source for finding more related cases, potentially even more important ones. There are at least 3 major ways to find cases from other cases. First, using the headnotes and topics assigned to the case to find other directly relevant ones. Then we have backward citation chaining. That is, using the citations in a case to find older relevant ones. And likewise, there is forward citation chaining, or using the citator to find newer related authorities. The first step in any one of these techniques is to locate a passage in your current case that seems most relevant. As mentioned in the last video, one of the most valuable features of case headnotes is that they are tied to the specific topic that a holding relates to. You can think of headnotes as a link to a relevant topic, and each topic as a container for every case on a specific legal issue. So, when you start with the case you have in hand, find the appropriate headnote, use that to go into the topic, and then retrieve the list of cases that share that topic. So let's take a look at how that works in practice. First, identify a salient passage of the majority opinion and look for the headnote number that preceded it. Then, click on the headnote number to jump to the headnote at the top of the case. Next to or above that headnote, you will see the topic assigned to it, which is also called a key number in Westlaw. You'll notice that the topics have multiple levels of generality and specificity. For this example, we'll choose the most specific topic. When you click on that topic, you'll see all the other cases that have a holding with the same assigned topic. Now note that in Westlaw, you will default to only seeing cases in the same jurisdiction as the case you came from. Now you have a list of cases that all have holdings on the same issue, and often that list of cases is narrow enough to quickly survey. Of course, almost any legally relevant passage from a case is going to be supported by precedential cases, and the passage will include the citations to those cases. There's a very good chance that a case that is cited in a holding that is relevant to you will also be relevant. Moreover, it is very likely that one of the cases cited will be the leading case on the issue, and you want to have the leading authorities on any issue, even if they apply the same test as the ones that you're already looking at. Now, you may already understand that you can use a citator to locate any case that cites the case you have on hand, but you can use the citator in a more focused way to find cases related to your specific question. Once again, we will be using headnotes. When you go to the headnote that is assigned to the relevant holding, below the headnote, you will see an option to find all the cases that cite to this case for the point of law tied to that headnote. This presents you with a very nicely focused set of cases, and perhaps it will include a case that applies the same principle to facts more neatly tailored to your situation, though obviously that is the best case scenario. If you already know a statute that controls the issue, but you need to find a case law that interprets and applies that statute, you have two possible routes to find the best cases. You can do a more focused search using the notes to decisions, or you can cast a wider net using the entire citator. When I'm researching cases that apply a statute, I generally start with the notes of decisions. In Lexis, this might go by other terms, such as notes to decisions or case notes, and they can be found at the bottom of the statute section. This feature selects a limited set of cases that cites to a statute, generally cases that give the statute some significant discussion, and then organizes the cases by topic. This topical arrangement is what makes the notes of decisions so valuable. It allows you to choose the topic that is most relevant to your issue, and then find the cases under that heading. Often, this is the most direct way to find a case on point. Now be aware that you will not always see the notes to decisions for every statute in Lexis, because this is the equivalent to when there's no cases under the notes of decisions in West. Now, the notes of decisions has its limitations, and the chief one being that not every case citing a statute is listed under the notes of decisions. If you don't find a relevant case or topic under the notes of decisions, you may need to broaden your research a bit and look to the entire citator to search across every case that cites to a statute. When doing this, you will not have the benefit of pre-assigned topics, but you do have a greater breadth of sources to draw from. In Westlaw's key cite, select citing references and then cases, and in Lexis's Shepard's, select citing decisions. From there, you can apply filters to narrow down to cases appropriate to your issue. The most relevant filter is likely going to be using a search term to find cases on your issue. Search filters require a little bit of trial and error, and there's no guarantee that there is a case directly on point, but this will often yield good results.